thank you, Paul. Thank you, Dan. Thank you all for coming. It's my pleasure to do this quick introduction. Debate comes at a time when America is certainly having increasing attention on gun control laws and the right to bear arms. A couple of decades ago, a colleague of mine wrote an article on the Second Amendment, and I remember thinking at the time how cute and esoteric it was. But possibly it remains a cute article. I haven't reread it for quite some time. It's not an esoteric area any longer. The Second Amendment is an important part of the debate, although I certainly think it's sort of legislative policy also at the center. We've got two outstanding speakers here to debate this matter. Professor Michael Dorf and Mr. Gura. For many of us in the room, Professor Michael Dorf needs no introduction, but I'm going to give one anyway. He's the Robert S. Stevens Professor of Law here at Cornell Law School. He's co-authored books, written many articles on constitutional law, writes a bi-weekly column for the Custody That's Free web magazine, The Verdict, and several times a week he focuses on his own blog, Dorf on Law. He's a real public intellectual as well as just a very good presence here in the law school and a terrific part of the faculty. Before he got here to Cornell Law School, just to go back in time, his resume was a clerk for Judge Stephen Reinhardt, Court of Appeals on the Ninth Circuit, and then Justice Anthony Kennedy of the United States Supreme Court. Before coming to Cornell, he served as a professor and vice dean at Columbia Law School, graduate of Harvard College and Harvard Law School. Mr. Gura is the founding partner of Gura and Possessky, which focuses on constitutional law. Among his many achievements, he successfully argued the Washington, D.C. handgun ban for the United States Supreme Court in D.C. versus Heller. He returned to the Supreme Court 2 years later to McDonald versus City of Chicago to successfully argue that the Second Amendment also applied to the states and government, local government officials as well. Prior to founding his firm, he served as Deputy Attorney General for the state of California, as well as counsel to the United States Senate Judiciary Committee, and earlier than that, litigation associate at Silly Austin in D.C. Began his career clerking down in North Carolina. I sort of pleased to see that connection between himself and the United States District Judge Terrence Pohl in the Eastern District of North Carolina. Graduate of Georgetown Law School, and then before that, Cornell University. So welcome back down. It's a great pleasure to have both of you with us today. Before I turn it over, I just want to give a thanks first to Dan Hartman and the Federalist Society, as well as John Underwood and the Cornell Law School's Second Amendment Society, as well as the many behind-the-scenes people that makes an event like this run so smoothly here at the law school. Our facilities folks, our communications folks, our IT media folks. So thank you all in the background. And now I'll turn it over to our speaker today. Thank you very much.
Well, thank you so much for having me here. It's great to see the turnout. The Second Amendment lends itself to many different types of debates. There are people who have philosophical ideas about the right to keep and bear arms. There are a great many different criminological debates and policy debates that people can engage in. But for our purposes here, since I'm a lawyer, we have a law professor, it's a law school, most of you are law students, you can see the trend here. I'd like to keep the discussion, for the most part, fixed on the legal aspects of this debate and how the courts should be determining the different kinds of cases that they are hearing now under the Second Amendment. The issue of guns in the United States, like all other issues, drifts in and out of the public consciousness for a variety of reasons, sometimes reasons that are quite sad and tragic, as we've seen recently. But it's a mainstay of the courts. It is a fixed part of the Constitution, and it is being litigated in many different ways, both by criminal defendants as well as by the types of clients I typically represent, which are individuals who file civil cases seeking to vindicate what they believe to be their rights in the federal courts. For the prepared part of my remarks, which I'd like to keep short so we can have lots of time for Q&A, I'd like to focus mostly on the one issue that I see as probably being the next major issue that the Supreme Court is going to have to resolve in the Second Amendment, and that's the issue of bearing arms, carrying handguns for the purposes of self-defense outside the home. The courts are split on the topic. They are reaching different results. And the split is one that obviously relates to a profoundly important issue, and it's going to have to be resolved sooner or later by the Supreme Court. It might yet be resolved in a case that I just recently filed a cert petition for, coming out of the Second Circuit here, P.L.L.C versus case. We had an adverse decision written by Judge Wesley in the Second Circuit. I suppose you can ask him more questions about that in a few days. My views of P.L.L.C, of course, are not quite so favorable, and perhaps we'll get to those in the course of the discussion. But let's start with what the Supreme Court has said on the topic. Many people believe that the Supreme Court has been silent on the issue. That's actually not true. Heller told us a great deal about the right to keep and bear arms outside the home, and the discussion, which was quite extensive in that case, was not dicta. It was necessary to reach the result in that case. You might recall that the city of Washington has had as its primary defense this idea that the Second Amendment related to a collective militaristic right to carry guns for some sort of militaristic purpose in service of the state militia. And in support of that theory, they looked to the term bear arms and said it had a uniquely militaristic, idiomatic meaning to soldier, to go off into battle. And this was, in fact, something that the district court accepted. It was a theory that the D.C. Circuit had rejected. In any event, it was before the court. And so the court had to define the term bear arms. And what the court did was, it started with the text, it started with the history, it started with tradition, and it very quickly reached the conclusion that to bear, at the time of the framing, as then as now meant to carry. And then the Supreme Court went looking through an opinion that had been previously written by Justice Ginsburg in dissent in a case called Muscarello versus U.S. Justice Ginsburg had offered a definition of bear arms in the Second Amendment, which the majority in Heller liked quite a lot, and they wound up issuing this as part of the holding. They held that to bear arms means to wear, bear, or carry on your person or in a pocket or in your clothing arms for the purposes of being armed and ready in case of conflict with another person. That's almost a verbatim quote. Obviously, I don't have the piece of paper in front of me, but it's something I've discussed an awful lot. In any event, you can look it up. It's in Heller. To wear, bear, or carry on the person or in clothing or in a pocket for the purposes of being armed and ready in case of conflict with another person. And 3 times Heller told us that the core purpose of the Second Amendment, its central aspect, was self-defense. The right to defend yourself was codified in the form of being able to have access to the means with which you would defend yourself. And so that's where it left us. Beyond that, of course, Heller gave us a variety of exceptions that prove the rule. Heller told us that we do not have the right to carry any type of gun, any place, any time, for any purpose. Well, that must mean we must have the right to carry at least some guns, some places, sometimes for some purposes. And Heller told us that we can ban guns from so-called sensitive places. The court did not give us any guidance as to how to define or locate these sensitive places, although intuitively we all know that such places must exist. But that must mean that if you can't take a gun into a sensitive place, which is appropriately off limits, why there must be some non-sensitive places where the right cannot be completely forbidden. Heller also engaged into an extensive discussion of the historical allowance for regulation on the manner in which guns are carried. Courts throughout American history had held that the government can prohibit the concealed carrying of handguns, and courts and legislatures have done so for quite some time. But if we read those cases, and Heller read those cases, we will see that the mic is coming in and out. I don't know what can be done about that. But in any event, the restrictions on the concealed carrying of handguns were upheld as a regulation on the manner in which you carry guns. It was thought that people who concealed no arms were sneaky, they were dastardly, they were up to no good, they were seeking an advantage of unfair surprise over their opponent, and of course virtuous people at the time carried their arms openly, and so we could ban concealed carrying. Open carrying, of course, was in that circumstance to be allowed. Now today I think we have a different societal understanding. There are many places where the carrying of guns is quite popular, and it's impossible to win state-wide offices be perceived in some of these states as being somehow hostile to the Second Amendment. I'm talking about places like Texas, Oklahoma, Florida. All of those license the concealed carrying of handguns fairly liberally, but open carrying is completely prohibited. Nonetheless, the rule that we derive is that the manner can be regulated. We don't have to like the particular manner that the state determines, but the state has the ability to do that. And of course, Heller also discussed at some length the ancient crime of affray, which dates back to the Statute of Northampton in 1328. And this was a prohibition that was enacted in England and carried over into our law in the United States on the carrying of dangerous and unusual weapons. A key aspect of that crime, however, was always that in order to commit the crime of affray, you had to be carrying those dangerous or unusual weapons in a manner that was terrifying to the public. And courts and treatises, many of which have been cited by Heller, if we go read those sources, were always careful to explain that absent that last element, that crime was not committed because, after all, at least in the United States, we did have secured in our Constitution the right to bear arms. What have courts been doing with this? Some courts have resisted Heller. They have refused to find the issue adjudicable. They have found all kinds of ways to minimize the right to bear arms outside the home. The Second Circuit opinion in P.L.L.C provides a fairly interesting approach. The court determined that the core purpose of the Second Amendment was not so much self-defense, but rather self-defense in the home. There's really no basis for that in Heller, but nonetheless, that's what the court held. And outside the home, the right was of so little utility that the court applied rational basis to uphold the New York's requirement that you could require an individual demonstrate proper cause to exercise what is essentially a right. Now, the court didn't say it was rational basis. The court said it was intermediate scrutiny. But if we actually read the opinion beyond the euphemistic labels that the court attached, we see that the court actually imposed the burden of proof on the plaintiffs, and it presumed that the law was constitutional. Those are the hallmarks of rational basis review. In intermediate scrutiny, as those of you who've had Cornell Law would know, the burden is always on the government to prove that there's a reasonable fit between an important purpose and the regulation and what it's trying to achieve. But here the court held, no, we are going to be so deferential to the state, citing all the same cases that Justice Breyer cited in his dissent in Heller, that we're going to actually presume that the law is constitutional and the plaintiffs did not overcome the presumption of constitutionality. Of course, there are other flaws in P.L.L.C, and perhaps we can address those as we get later on to the Q&A. A couple weeks later, reaching a very opposite conclusion in the Seventh Circuit, Judge Posner, in Moore v. Madigan, struck down Illinois' total ban on the carrying of guns. Judge Posner, for the panel, read bear arms in a very straight fashion. He said, look, the history here is settled. Heller told us that to bear arms means to carry them. The purpose of self-defense is what's protected here. The need for self-defense arises out of the home as much as it does inside the home. And so whatever else Illinois might do to regulate the carrying of guns, and there's no question that Illinois can regulate the practice, it cannot absolutely, totally forbid the practice at all times and places for all people with no exceptions. The reasoning of these two opinions is directly at odds with each other, and we'll see if the Supreme Court takes upon that conflict. I'll turn it over now to Mr. Dorf.
So let me just begin by thanking the Federalist Society, the Cornell Law School Second Amendment Society, and especially Alan Gura for coming today. It's great to see so many people here interested in this subject. You know, we build these things as debates because that puts bottoms in seats. But I think you'll find that I'm not actually going to disagree with all that much that Mr. Gura said, although I do have a somewhat different perspective. I actually don't have strong views about what the right policy ought to be with respect to the availability of firearms for private possession and use. Long before Heller, I took the position in my academic work that there is a fundamental right of self-defense, although I said that for textual and historical reasons, it's awkward to fit that into the framework of the Second Amendment, although, of course, it can be done. Courts can, pretty much do whatever they want in this regard. But I do think that the policy questions in this area are quite complicated. I think that the various proposals tend to be exaggerated both by their supporters and by their opponents. So let me just give you one example. President Obama gave a speech a couple of weeks ago in which he listed, 25 things that his administration was going to do about guns. It turns out it was really 3 things. They were going to take a few small executive actions to tighten enforcement where they could of existing background checks and so forth. And then they were going to ask Congress to tweak the law regarding background checks, and then to reinstate the so-called assault weapons ban. And I'll come to talking about that in just a moment. But because they listed all these things, I think it got the supporters really excited. Yes, finally the president's going to do something. And it got the people who were worried about this, people who support their Second Amendment rights, very upset. Look at, he's listed 25 things he's going to do. I think, in fact, the political space for regulation of firearms is fairly narrow. It tends to get exaggerated because of the nature of our politics. Okay, so what about the legal questions? It's absolutely an open question about what will happen with respect to public carriage. I think if I had to predict what the Supreme Court will do, and I think that they'll either take P.L.C. or they'll take the Moore against Madigan case, because it's not exactly a circuit split, because you can say that the Illinois law is more restrictive than the New York law, and the New York law gets upheld and the Illinois law gets struck down. But it's pretty squarely a circuit split, so I think they will take it. If I had to predict what they would do, I think I'd probably say that they will strike down something like the Illinois law, and they might strike down, they might uphold the New York law, but they would find that there probably is some right to carry. That is to say, I agree with the analysis that Heller is probably best read to indicate that the justices who wrote and signed on to Heller think that the Second Amendment protects a right to possess firearms not only in the home, but also in public, to some extent, right, in the non-sensitive places that count as public places, because I agree otherwise, what does it mean to say a place is sensitive if all places are sensitive? So I think that's probably right in terms of divining the intentions of 5 justices of the Supreme Court. But I must say, some years ago I was in a discussion with a colleague of mine at a constitutional law conference. This was before Justice O'Connor had retired. And after the first day of the conference, we were just sort of chatting, and this colleague who teaches at another law school said to me, "Don't you find it depressing that so much of our job involves trying to read the mind of Sandra Day O'Connor?" And that if we want to know what does the Second Amendment have to say about the question of whether you have a constitutional right to go about in public with a pistol on your hip, whether concealed or in plain view, we want to know not only what we think 5 justices of the Supreme Court are going to say about that, but what we think the best reading of the text, the history, the doctrine, the settled practice is. And that, I think, is a somewhat more difficult question. There's a recent law review article by Darrell Miller, who's a University of Cincinnati law professor, with a very bad title for his article. And I think the title has misled a bunch of people. The title is Guns as Smut. And then there's a subtitle, because there's always a subtitle. But the basic idea is that he draws an analogy between the First and Second Amendments. Now, he got this idea from me. Because I had done this in a symposium in the Syracuse Law Review, but I did it just sort of speculatively, thinking, hey, maybe this is something that is possibility. The idea is, if those of you who've taken the advanced course in the First Amendment will remember a case called Stanley against Georgia. Stanley against Georgia is a case that holds that the government of Georgia, apparently, can't prosecute somebody for possession of obscenity in his home. It's a little bit of a weird case, because obscenity is, if material is obscene, that means it's outside the protection of the First Amendment. And so how is it that the court thought that there was a right to possess something you don't have a right to possess? Well, the answer was, they said, well, there's special protection in the home. And the court pointed to specific references in the bill, other parts of the Bill of Rights, in particular the Third and Fourth Amendments, which single out the home as a kind of special place. And so the suggestion is, and this is, you can find hints of this in Heller and McDonald, although I agree it's not the overwhelming thrust of the opinion, but the suggestion is that there's more protection for various rights in the home than elsewhere. And you might think that that would be true with respect to the Second Amendment as well. Now, the question then is, what methodology ought the court to use to decide whether there is a right to carry firearms outside of the home? And let me suggest that this poses a conflict within sort of conservative legal thought. It poses at least a potential conflict between two versions of originalism. One version of originalism, what we might call old originalism, says that when we want to figure out what a provision of the Constitution means, we look to the intentions and expectations of the people at the time the provision was adopted. And what Miller does in his article is to say that given the important distinction between a so-called select militia, which are a small group of individuals who are armed, and the general militia, which is the body of adults capable of bearing arms, the framers would have been very worried about people walking about armed when they weren't doing militia service, that is, when they weren't called to muster by the government. And so he makes a historical argument for why the right to keep and bear arms was a right to keep in your home your arms and to bear them when called to muster. Now, I think this argument will lose for two reasons. One, I happen to know the identity of the justices on the Supreme Court, and I just think they're unlikely to buy it, which isn't to say it's a bad argument. But two, I do think that the court, having defined bear to mean carry, they're not going to say that you bear your arms when you carry them around in your living room or in your bedroom, and so forth. But that doesn't mean that that's a correct interpretation ab initio, right? That's basically me acting like a mind reader, now no longer for Justice O'Connor, but for Justice Kennedy or whoever the median justice is on this issue. So I think we're in agreement about the likely outcome in the Supreme Court. I'm just not sure that that's the right outcome in the sense that we might talk about right and wrong outcomes standing outside of the opinions. Let me say one other word about, right, so I said there's a conflict within originalism. I gave you one side of the conflict. I didn't give you the other side of the conflict. Okay, so that's one possibility. That is, if the court signs on to the Miller view, which I don't think they will for my legal realist reasons, but if they did, they might find that the history of limiting firearms in public cuts against a current public right to carriage. But there's another way of doing originalism, which has become fashionable, we might call new originalism. And what new originalists say is, well, you don't include in the meaning of a constitutional term all the intentions and expectations of the people at the time, because those weren't what was adopted. What was adopted was, as these new originalists like to say, the original semantic meaning. Original semantic meaning is a fancy way of saying original meaning, because semantic just means having to do with meaning. So it's like the original meaning. In any event, and the idea here would be, Well, you figure out what the word means, and then you get a general principle. And from that principle, you derive a whole bunch of doctrine, and then you're off and running. And here the principle would be, you have a right to such weapons as are reasonably needed for self-defense, and the government can't go too far in restricting your ability to have firearms for self-defense. I think that, and that's more or less the way Judge Posner read Heller and McDonald in Moore against Madigan. I think that is a fair reading of the case, but as a lot of people have been beginning to notice, it's not really different from what we might call living constitutionalism. That is to say, you do what you can to figure out what the word means, and then in the future cases, you're sort of off and running. And so the Second Amendment will start to look a lot like the First Amendment, the Fifth Amendment, substantive due process, and all the other things that I thought you guys at the Federalist Society hated. That is to say, a source of judges figuring out what they think the Constitution means. Now, I happen to have not that much of a problem with that, but you guys ought to. I think I'll stop there because I'm coughing too much.
Well, let me briefly respond. First of all, I believe the desired term for what you call neo-originalism is original public meaning originalism. And the theory here is very simple. Why do we revere the Constitution? Why do we care about it so much? Well, why does it enjoy a higher status in our law than a mere act of Congress or what the Ithaca Town Council might vote on? Well, the reason is because the Constitution was a document sent out for public ratification. In order to amend the Constitution, we need not only 2/3 of each house, but 3/4 of the states. And at the time of the founding, of course, this is a document that went out to the people to discuss and debate. And so the concept here is that we interpret this according to its original public meaning. What would the words of this document have meant to the people who were going to vote for its ratification, one way or the other? And so if, a dictionary of the time is probably a better source than some legal treatise to determine the meaning of a constitutional provision, because you want to know, what do the people understand this language to mean? You certainly don't want to go to legislative intent, because that is often inscrutable. Oftentimes, it's going to be incomplete, especially when you go back in time into the 1700s, where you didn't have very detailed records. There wasn't a literal transcription going on of proceedings. And in any event, we don't engage in sort of a historic psychoanalysis of what the framers were thinking. Rather, we have the text left behind, and it's what that text meant to people at the time that should govern. The idea that gun rights are more acute in the home, that they have greater protection inside the home, is not a radical concept. That's the way we treat all of our rights. It's how we treat the First Amendment, obviously the Fourth Amendment. But that's not to say that your rights don't exist outside the home simply because inside the home they're subject to greater protection. In Kachalski, one of the things that the Second Circuit cited for this proposition of why the home is more important, they went and talked about Lawrence v. Texas, obviously the right to engage in consensual intimate relations with other adults. And of course, Judge Posner shredded this. He noted that that relates merely to the nature of the right itself. You don't have much of an interest in having sex outside on the sidewalk. What you do in your bedroom might be protected, but certainly bearing arms, of course, means to carry them, and since it doesn't mean walking around your kitchen with a gun, why that right inherently must mean being ready for conflict or confrontation with another person. For people who think that the militia clause limits somehow the purpose of keep and bear arms, I think Heller's already gone over that. I'd be happy to discuss that at the Q&A portion. There's no point in relitigating it, but even if people want to relitigate that, it's certainly not a logical conclusion to suppose that the militia purpose limits the meaning of bear arms. You can only bear for the militia, but you can keep for private purposes. That there's absolutely no way grammatically or linguistically or logically to parse out these two concepts and have one bound and one not bound by the preamble. And for people who want to go past Heller into the past, not necessarily be bound by precedent, but rather be bound by by text and history, that's obviously something that I would encourage. And in fact, we can go back to English courts, to cases like Sir John Knight's case in the 1600s that upheld the right of a gentleman to go riding armed for their protection on the highways. The idea that in English law the right to bear arms was limited to the home has absolutely no support whatsoever, and oftentimes it was decided in contexts that were plainly reaching outside the home, as it was in the early part of our history and early American constitutions and other legal sources that we can draw upon. So bear arms didn't mean bearing them inside your house. The American Constitution didn't redefine the nature of the right. Remember, the theory of our Constitution is that it secures rights that are thought to be pre-existing. The most important word in the Second Amendment is the article the. You're talking about the right to keep bear arms. It's a pre-existing right, just like we have the right to free speech in the First Amendment, the right of the people to be secure in their homes. In the Fourth Amendment, you're talking about a concept which is thought to inhere inherently in people and human beings. It just so happens we live in a country that's aligned enough to protect some of these concepts in our founding document. And finally, as far as the discussion of judicial review, there are people on the legal right, so-called conservative-minded attorneys and judges, who have a problem with Marbury versus Madison. They seem to think that it's a terrible idea for judges to actually enforce the Constitution, and we must always be completely deferential to the political branches in whatever they do. I think this is largely a reaction to Roe versus Wade. There are many people who really dislike that case.
Started with Brown.
I've not met too many people that are opposed to Brown. I've met a lot of people who oppose Roe v. Wade. But generally speaking, the idea was that this terrible decision came out because judges have the power to review democracy, and if we take away that power or pretend that power doesn't exist, then we won't have these terrible outcomes. That is not what the framers had in mind. If you look at the debates in the Constitution, the idea of judicial review was definitely discussed. This was not just something that Justice Marshall invented. And of course, the Constitution structurally protects the judiciary from the political process. Judges serve for life during good behavior, even if they issue lousy opinions. Their pay cannot be cut. And the idea was always that somebody in any political system has to enforce basic concepts. In some countries, you have a king or a dictator who's the ultimate decider. In our country, on constitutional issues, it's going to be a Supreme Court that interprets the law and is actually a co-equal branch of government that applies the constitutional limits against the political branches. The idea that you're going to have courts deferring to the political branches is one that not only runs counter to the original idea of this country, it's actually quite dangerous. It's not one that I support, and I'm sorry, Professor Dorf, many members of the Federalist Society have a struggle with that as well. Not all. It's true we have debates about this, but the judicial review is here to stay. What's good for other parts of the Constitution should be good for the Second Amendment. Now, it doesn't mean that courts will always get the Constitution correctly. I am very dissatisfied, not just with some Second Amendment opinions, but also with some First Amendment opinions. I think the Fourth Amendment's been given way too narrow reading. I think the 14th Amendment's been given very narrow reading, not one that was understood by the people at the time who ratified it. But the solution to bad decisions is to make good decisions, not to put the courts out of business, because then you're at the mercy of the political process, and we've lost the protections that the Constitution are supposed to give us.
All right, so I agree with 80% of that. But I want to just raise one point, and I think we should probably open up to questions. So this is a sort of, it's not quite a historical point unless you count the last 20 years as history, which I don't think I do. If you look at the landscape of debate over the meaning of the Second Amendment over the last 30 years or so, what you find is that one of the best arguments for the individual right view has almost completely disappeared from polite discourse. And that is the so-called insurrectionist view. It's an argument that says the point of the Second Amendment is so that people can have guns, so that if the government starts to tyrannize them, they can fight back. And this is, It makes sense of the Second Amendment as a whole. It's right there in James Madison's Federalist number 46. And it's a perfectly plausible textual interpretation. It's invisible, practically, in Heller and McDonald. Why? The reason is that what decides constitutional doctrine is partly text and history and judges trying to do their best to figure out what the law is, but also what is politically feasible. And after Timothy McVeigh and the discrediting of the militia, the so-called militia movement, and you might say after the Civil War, which was an attempt to exercise an insurrectionary view of the Second Amendment, right? It is no longer feasible as a practical matter to argue for the insurrectionist view. You can't even get elected to the Senate from Arizona or Nevada. Where's Sharon Angle from? Nevada. From Nevada, right? Arguing for the insurrectionist view of the Second Amendment. It's not because it's a bad textual or historical argument. It's because as a practical matter, we as a society have come to a different place with respect to insurrection. And to quote Justice Scalia, right, he's a textualist, he's an originalist. To his credit, he then adds, I'm not a nut. Right? And so I think that we have to try to bound this discussion by what is practical and reasonable. Okay, I'm going to stop. And you want to go right to
I can respond really quickly to that. The term insurrectionist theory is not the one I would use. How about the American revolutionary theory? You know, very few Americans think that Timothy McVeigh was a good guy or had the right idea. Very few Americans think King George was a good guy and had the right idea. I mean, how many people here, show of hands, think the American Revolution was a good idea? Okay, still popular. Otherwise we'd have to bring the Queen over obviously there's the concept that you can't find yourself living in a political system that is broken down, where the courts aren't open for business, where you have the tyrannical oppression. We've seen that many places still, sadly, today. Obviously, the last century, no need to recount the horrors that fell upon much of the world. And so I don't think that it's, Americans don't understand the concept that there are times you're going to have to get rid of the government. It's just that we don't live in that time here today. Our courts are open for business. We have elections that work fairly well. We are not in a revolutionary moment here. There's nothing wrong with America that can't be fixed by a few lawsuits. So there's, and also it's simply not a practical litigation approach. You're not going to go into a federal court and say, look, I need to be able to access this particular weaponry because I want to overthrow the government tomorrow. Can you please strike down the law forbidding me from accessing the means of overthrowing the government? It's kind of an odd legal argument to make, so it's not really going to form the basis for any doctrine. However, there's no question that the framers, I would agree with you, definitely had in mind the idea that we are going to make the decision to give people the ultimate check on the government by reserving some balance of power in the population at large. And we can play games of alternative history, what might have happened, but it is one thing, however, to note that we have enjoyed a couple hundred years of stable, peaceful democracy in a very diverse nation with a lot of people have different ideas about things. And I would suppose that the Second Amendment provides some of that stability. If ever at any time, especially early in our history, it was thought that somebody could knock over the American Republic, the Second Amendment may have been a check on that. We don't know, it's impossible to say. But given some of the things that have occurred that have befallen other people around the world, I think it's a good thing that here in America we've reserved the ability to have some force among the populace.
Thank you. Really great debate. Now I'd like to open it up for Q&A. Everybody.
This is for Professor Dorf. I want to pick up on something that you mentioned. It seems like you're suggesting that since this new originalist interpretation has come about and kind of has transcended strict constructionism, there's almost a level of being on par with living constitutionalists as far as interpretive discretion. But I think there's a question of degree that I would like to get your thoughts on. Don't you think there's a greater interpretive leap with words like substantive due process that are purely abstract in comparison to words like arms or speech that are a bit more grounded, and the interpretive leap that people are taking in deriving what means an arm or what means speech is different than the interpretive leap trying to determine what means substantive due process?
So my answer is it depends, right? It's a great question. So that's not a difference between old and new originalism or between new originalism and living constitutionalism, right? There are new originalists who fully believe in substantive due process, and they do so on new originalist grounds. I'm not saying they're right or they're wrong, but I think you're just slicing it on a different axis. The argument that you're making is that there's a difference between giving effect, including interpretation and construction and extrapolation and interpretation to enumerated rights versus finding unenumerated rights. So that, I think, is a fair point. It's a point that's been made by a lot of people, but I don't think it's about new originalism versus living constitutionalism. That's it.
I know you've been there and done that with Heller versus DC. So maybe this is a moot point. But the whole point about militia and right bear arms. So when you read the Second Amendment just as an English sentence, it seems very clear that the operative clause is based exclusively on the first clause. That it's only in terms of a militia that you have the right to bear arms. And the Constitution of Vermont and Pennsylvania is very specific that the right is also for self-defense. So could you explain simply how the Supreme Court managed to divide those two things and bring in the idea of self-defense?
This is for you, obviously.
Sure. Well, first of all, I disagree with your I think the most natural construction of the Second Amendment, and consistent with canons of statutory interpretation, is that the preamble does not limit or alter the operative text unless it would be a nonsense or absurd result, a result that would not be consistent to not do that. The preambular language explains why it is that you are taking the action of the operative text. The operative text says the right of the people to keep and bear arms, again, referencing a pre-existing right, shall not be infringed. And we know that this right existed in English law in England before, where there was no meaningful militia system at all. It was a right that was described by Blackstone. This was something that had pre-existed absent a militia system. Now in the United States, the first clause gave us a reason, perhaps the primary reason for the codification of what followed. Why do we say that the right of the people to keep and bear arms shall not be infringed? Well, it's because it's necessary to the security of a free state. Because the militia system is something that was thought to be vital to national defense. But it's important to remember how this militia functioned. The militia of 1791 depended entirely upon ordinary people who brought with them to militia service their own arms that they had in common use at the time for their own private purposes. If people didn't have the right to keep and bear arms, they wouldn't be able to function as militia because they'd show up to militia duty carrying nothing. And even if they were given a gun, since they did not have the right to keep and bear arms, they wouldn't be well practiced in the right, they wouldn't be very useful. The idea that's explained over and over and over again in Federalist 46, as was mentioned by Professor Dorf, and other places, is that Americans at the time understood that guns were a common feature of American life. It was thought to be a benefit that Americans had over Europeans, that people were very skilled in the use of arms. This is how you got dinner in many places. And that this advantage could be harnessed for the militia purpose. That doesn't alter the right of the people. And remember, the people is a much broader concept than the militia. It's the people who have this right even if not all the members of the people are the ones who are going to be suitable for militia duty, just like the right of the people exists in the First Amendment, just like the right of the people is in the Fourth Amendment. So it is the right of the people. We codified for this reason. It doesn't mean it doesn't exist. It doesn't mean we don't find it useful for other reasons. But that's the relationship.
I have a question about the last thing that you said. I guess providing a sense of the original, or what Professor Dorf calls the insurrectionist interpretation. I mean, clearly, I think Heller and McDonald aren't going to be enough to give enough firepower to, I guess, accomplish the purposes that you said is also an important purpose of the Second Amendment. I guess my question is, if that's still an important purpose of the Second Amendment to be the final check against tyranny, how far does that take you, I guess, ideologically, what kind of weapons you're going to use?
Yeah, well, first of all, it's important to note that I guess there's two questions lurking there. I'll try to answer to both of them. The first part is, I'll just the second part first. The Second Amendment presupposes that you will have access to the kind of arms or of the kind in common use for traditional lawful purposes by individuals. At the time of the framing, there was really no difference technologically between the types of arms that you would take with you hunting or that you would defend yourself with and the type of arms that were useful in military capacity. Obviously, technology has changed over time, and today's military would use many different kinds of weapon systems that normal individuals in daily life would have absolutely no use for. That doesn't change the fact that it's still the right of the people to use the kinds of arms that would be expected to be used in common use for traditional purposes. So even though today's military might find a Predator drone useful, the fact is that you're not going to find one useful in your daily life. There's no drone season for deer. If someone attacks you on the street, you're not going to call the drone strike on them. So there's been a divergence, but that technological divergence doesn't change the core interest of the right, which is the right is for personal arms adaptable to personal purposes. Now, does that change the utility of arms for the...
Can I interrupt for a second? Why would you want to say that? I mean, I know why you want to say it, because you don't want to sound like a nut. But
Well, I'm actually not a nut.
No, I agree. Right. Look, you don't want to sound like a nut even to yourself. But we wouldn't say that about the First Amendment, say, right? So if we're trying to figure out what does freedom of the press mean, well, at the time of 1791, the way you got your message out was by using a printing press, and you'd make a broadsheet or something, right, or a pamphlet, right? And you'd say, well, the purpose is to facilitate self-government, self-expression, etc., right? But the means that was chosen, the operative clause, is the free press. You press ink onto paper, right? That's the right. Now we live in an age of different technology, and somebody comes along and says, hey, I want to be able to fulfill the actual purposes of the First Amendment, so I have a right to promulgate my message, my press, on the internet, even though it's not literally part of the press. Wouldn't we want to say there that, well, of course, yes, your right of freedom of the press includes the right of the Wall Street Journal or the New York Times or whatever, Ithaca Journal, to have a website. And why is that different from Drew's hypothetical person saying, I've got a right to my RPG or to my, surface-to-air missile because I'm worried about the government's black helicopters?
Well, I'll tell you why. First of all, the Second Amendment, as Heller explained, is not technologically hidebound. So this is not an argument that says you only get to keep muskets and smooth bore rifles, things like that. No, you have the right to use whatever arms would be available to you in common use for the traditional purposes of the right to bear arms. And so, yes, of course, the right to bear arms protects new firearms technology, protects revolvers, for example, that I think came a little bit after 1791, although they were pistols. It protects semi-automatic rifles, because that's the kind of rifle that generally exists today for self-defense, for hunting, for normal purposes. Not fully automatic rifles. We can get to that. I'm sure there'll be a question on that. But So there's no technological limitation in the Second Amendment. But the purpose of the right to keep and bear arms is personal, is primarily personal self-defense. It also, another purpose I'm sure courts would find would be sport, hunting. Those are the reasons why you would have a gun in common use. And I don't
You're
know.
defining purpose at this sort of intermediate level of generality, right? The core purpose, I thought, was to protect us against tyranny. Why don't we revert back to that?
Well, in 1791, you could use cannon to protect yourself against tyranny, but I don't think that people carry cannon around. It wasn't something that you would normally have around the house. And I think if you wanted to go to Walmart and buy cannon today and sue the government because they wouldn't let you have that, I think there could be a fine argument that the government would have to say, look, this is not the kind of arms that were intended, the applications that were intended were not purely militaristic applications.
We've got a textual argument. It's hard to bear a cannon, but an RPG.
Well, but the fact of the matter is that an RPG is not adaptable to a traditional purpose to which the right to arm existed. People in everyday life weren't overthrowing the government. Overthrowing the government was something that was quite rare, actually. We did it once in our country's history. It's nice to have the ability, I suppose, to the extent that you have arms of the kind that would be in common use, but it does not mean that you have the right to militaristic arms because the technology itself has diverged. And I suppose I forget the second part of the question that I saw there, but
Someone else will ask.
somebody else will ask it.
Are the police obligated to protect someone from bodily harm, and if they fail to do so, can they be held liable?
No, that's the public duty doctrine in American law and torts classes learned that no, there's no. You cannot sue the police for failing to protect you, unless there's a special relationship. If they actually responded and done something to bring themselves into a relationship with you, you can't sue the police.
I think that's correct as a statement of the existing law, and I think that there are good reasons why one doesn't have a right to sue the police, having to do with nuisance suits and so forth. Nonetheless, I think that as a sort of basic principle of decency, the police ought to have some duty, perhaps enforceable through other mechanisms, to protect people, right? I mean, that's, I think people, regardless of whether you think people ought to, in addition, have a right to protect themselves, it's hard to see why you wouldn't want the police to have such a duty. But, you might say it's not necessarily a constitutional duty or something like that.
It's a tort debate. We have the public duty doctrine in the U.S. I think it's probably overextended in some areas, but generally speaking, we'd like the police, like all public servants, to do a good job and pay attention to their work and try to help people. It's sort of the idealistic vision. That's why we have the police, right? Sometimes they do that, sometimes they don't. And I suppose that there are definitely ways we can address inefficient or bad police officers. That's more of a political question.
A question about New York and how you would each approach the recent New York law, arguing for or against it, where I think that some of the key components are it's essentially banned classes of weapons which traditionally, and even at the federal policy level, are not considered outside of the norm, such as a handgun that can accommodate a 10-round magazine. Literally an odd number, 7. How would you argue for or against New York approach it?
I would. Do you want to answer? Well, the 7-round limit to me is clearly unconstitutional for the reason that you mentioned. Americans have an expectation to find in common use handguns that have more than 7 rounds. And so a 7-round limit is plainly unconstitutional. This is really a matter of physics more than anything. A handgun is designed to fit in the human hand. The human hand is generally a certain size. And so if you have bullets of a certain diameter, you have a certain volume of space. A gun that has bullets in it will usually hold, in traditional calibers, 12, 15, 17 rounds coming out of the factory without any magazine that protrudes from the frame of the handgun. And that's what people in America generally experience. Dick Heller's gun that was at issue in Washington, in the Washington case, was a revolver that held 9 rounds. I guess it's illegal in New York now. It was a Western-style .22 revolver, and I suppose there's 2 more than but that's an old firearm. So yes, that's a little bit excessive. Now I should say that there's another issue here when we talk about magazine restrictions, and that takes us back to the idea that not everything that you can own and use under some circumstances is appropriate in all circumstances. There are many magazines that would be perfectly appropriate in a wilderness area or at a gun range that would be inappropriate in Central Park or walking down Fifth Avenue. So, for example, if you went to a gun range and there was a guy shooting a rifle that had a 20-round magazine, that could be the most normal thing that you might expect to see at a gun range. But if you see a gentleman walking with a rifle and a 20-round magazine walking down the street in New York City, then I think there's some cause for concern there. And so, yes, I think that states can regulate the amount of ammunition that one takes with him or her walking down the street. At some point, it's no longer something that people would expect to be using in traditional applications, and concerns are raised about what this individual has in mind. But again, that depends upon the time, place, and manner, and the circumstances. But as a general possession question, to prohibit anything that contains more than 7 rounds it's plainly ridiculous, and it should be struck down.
So I think that it's a good question, Bill. I think that this points out to me a potential conflict between 2 arguments Justice Scalia makes in Heller. Right? On the one hand, when he's listing the traditional exceptions to the right to keep and bear arms as he's defined it, one of the things he says this exception is dangerous and unusual weapons. And so it's the sort of converse of that, this idea of weapons in common use, that gives him this definition, right? Weapons in common use for traditional purposes. So that suggests one kind of a test, right? You sort of look around and you ask, well, are these the sorts of weapons that people have traditionally had? And there's probably some magazine size that sets a limit there, right? Maybe, 10 bullets, that's about pushing it. So maybe 20 is okay, but not 25, whatever. And you're going to have some arbitrary line drawn from it. So, okay. So that would be based on one test, which is, are they unusual weapons or especially dangerous weapons? Another question is, is this the sort of weapon that is necessary for self-defense, right? If we ban the various weapons that are banned, does that leave enough room to have the kinds of weapons that you're going to need for self-defense? And it seems to me quite possible that the threshold for number of rounds you need for self-defense might be lower than the sort of unusual number, right? It might be that for reasons of convenience, tradition has set the usual limit at 20 rounds, but that all you really need for self-defense is 10. And, any number that the Supreme Court picks, or that any number the Supreme Court picks is going to look completely arbitrary, which is one reason why you might think that this is a matter for legislative judgment, again, above a certain minimum threshold, right? When the Supreme Court did this with jury size, they look ridiculous. They say, well, you can have a non-unanimous jury if the jury has 12 people, but you've got to have a unanimous jury if it's as few as 6 or anything under 12, right? And that's going to look very, very strange. So that's an argument, at least for some deference to legislatures. Although I agree, there's going to be a number below which the court's not going to let them go, and then they'll look ridiculous.
Well, if the jury had only 2 people on it and they didn't have to be unanimous, then, well, I guess having hard, but fine, a unanimity requirement with 2 jurors or 3 jurors. I think that would probably not be an issue for legislative deference, and you'd have to go into tradition and history. And the same thing is true. Look, there are going to be lines drawn at some point, and that's just the reality of what we do in the law. And there's a role for deference sometimes, but not when you have an enumerated constitutional right, which is fundamental. At that point, you really do have to look at history and tradition. And a 7-round limit would absolutely not fly. You did mention one thing in passing that I think should be addressed, and that is this idea that we determine what is allowed based upon what is not allowed, or the reverse, that is that we can ban the following firearms because it still leaves you with the others. That's kind of like saying, well, we're going to prohibit the following faiths because you still have access to these other churches, or we're going to ban time because you can read Newsweek. And that's something that was rejected both by the D.C. Circuit in Heller when it was called Parker, and it's something that Heller rejected as well, this idea that the availability of something else is an excuse to ban something which is protected. We just don't do that in the law. At the D.C. Circuit, Silverman wrote, that's like saying that as long as we allowed sabers, we could ban guns. In fact, when the city petitioned for certiorari, they first presented the question as whether they could ban handguns because they allow rifles and shotguns to be registered. We challenged that question. We thought that was not an appropriate question, that was not accurately reflecting the issues in the case. And the Supreme Court agreed with our framing of the question and actually issued certiorari based on having rewritten the question along the lines that we had proposed, which was more along the lines of, can you ban handguns, not whether can you ban them because you allow other things as well. That's just not the way we do things.
Yeah, I'm just extrapolating from the notion that. Let me give an example. Right. So suppose that I invent the death ray, right? And the death ray, it's like the death ray 2.0. It's not a gun, right? It shoots right out of your eyes. Okay. Now, I take it. Your view, well, I don't know what your view of the death ray would be, but from what you've said, right, the government can ban the death ray if they jump on it right away, before they become in common use, right? Once people start using death rays for hunting and self-defense and other things, then it's too late. I guess I think that whether the government can ban the death ray or not should depend, at least in part, on what one's alternatives are to the death ray, as well as how dangerous we think the death ray is, right? Can you accidentally set it off by blinking? In which case, that would be a good reason for banning it, or at least banning it until they perfect the technology. So all I'm saying is, right, that there are a lot of things that the court says in Heller, right, to try to qualify its opinion, to sort of push it in one direction or another. And, you know, one way of understanding that is as a full employment bill for lawyers, so I hope you're hiring.
Well, I think you need patent counsel on the death ray, first of all. I wouldn't discuss it publicly or the details for it. In any event, no, it's more of an expectations-based test. It's kind of like in the Fourth Amendment. The idea is not whether or not the government can ban it quickly before it attains widespread acceptance. The question is whether people, considering this technology, would find that it has application to traditional lawful purpose such that they would be able to expect to see it in common use. Let me give you two examples. In Washington, D.C., we had a handgun ban for many, many decades, 30-some-odd years before it was struck down in Heller. There were no handguns in common use for lawful purposes in Washington, D.C. Handguns were in common use for non-lawful purposes, but not by law-abiding citizens, of course. People follow the law, they didn't have access to it. Nonetheless, the Supreme Court could look at the American experience and say, look, handguns haven't been here for a long time, but we know that this is the kind of arm that Americans would use for self-defense and other lawful purposes, and so D.C.'s somewhat old ban at that point was struck down. In the Fourth Amendment, we see this as well. I mean, you have a right against unreasonable searches and seizures, but what does that really mean? In the Kylo case, the Supreme Court held that the police are not allowed to fly a helicopter over your house with heat-seeking equipment to detect growing tools being used to grow marijuana without a warrant. Now, of course, the framers didn't have helicopters. Maybe they had pot. We don't know. We'll talk about that later. Yes, but they didn't have helicopters. The police in 1791 weren't using this type of equipment. Nonetheless, it was subject to background expectations of the Fourth Amendment. In the wiretapping issue is another one. You know, in the 1920s, Olmsted said you have no expectation of privacy against the government listening into this newfangled telephone technology. Yet, when Mr. Capps was making his phone call on Sunset Boulevard in the 60s, and he argued that he had an expectation in the privacy of his phone call that the Supreme Court changed its mind, and it was because it reasoned that people did have, under traditional background expectations of what we think of privacy and the government's ability to intrude into our lives, an expectation that we could use the telephone without being listened to unless the government had a warrant. And so, likewise with the death ray or anything else, I think you have to see whether this is the kind of thing that traditionally would have an application such as people would expect it to be used. It's not a question of how long it's been on sale or how quickly the government banned it.
What work is the word traditionally doing in that account if it's not a question of time?
It's the application. Self-defense. Now, suppose your death ray has a wonderful application for self-defense. I suppose that you could perhaps make an argument for it. We haven't quite seen how it's functioned. Let me give you a better example, which is stun guns, tasers. That's a new kind of arm that's been invented. It has defensive applications. This summer, a court in Michigan's intermediate court, upheld people's right to carry tasers. Struck down Michigan's ban on the...
Well, that seems an a fortiori case from McDonald, right? I mean,
but there you have new technology, not quite a death ray, but nonetheless, zaps people, I suppose. And they held that was protected. New technology. Not everyone has them, but all the same, it kind of functions like a defensive arm. It fulfills that role, so it's protected.
okay.
Leave the death rate at any more questions?
Can I ask a second question?
Sure.
The idea of insurgency. So, last question. People are always saying that the Second Amendment was developed to protect the people from a government. The government growing too big and taking over their lives. But the people framing the Constitution were the insiders, the establishment of the time. And they're framing this maybe to protect themselves. Concerned more about sedition, people rising up against the government, than they would about people protecting themselves from the government. Can you comment on the idea that the Second Amendment is really a clause not to protect the people from big government, but baby government trying to protect itself from sedition of the people?
Yeah, so there are a number of historical accounts about what the Second Amendment is, quote, really about. So one such account, and I'm not a good enough historian to know whether what I think of each of these, because I haven't read the primary sources, I just sort of read these accounts. So one account is, what we know, right, the Second Amendment is not part of the original Constitution. It's part of a package of rights that are demanded as the price of ratification in various ratifying conventions, because people are worried that the strategy of enumerated powers will leave them vulnerable to abuse of those enumerated powers by the federal government. And so the Second Amendment is one of these. There's a good argument to be made that the entire Bill of Rights is chiefly a federalism provision originally. That is to say, it doesn't apply against the states. Right? It's the holding of Barron against Mayor and City of Baltimore, which is widely regarded to be accurate in terms of people's expectations. So it is chiefly about a limitation on the federal government. But you can understand it, this is on the insider-outsider story, you can understand it as not what the insiders who framed the Constitution wanted, right? That they're, this is again sort of giving credence to the sort of insurrectionist view. Right? It's what the ratifying public demands as the price of doing things. Now, my own view is that it was a sort of stupid bargain on the part of the insurrectionists, right? Because most of the concern expressed at the time is not about self-defense. It's about the dangers of a standing army. And the Second Amendment does nothing to limit the power of the federal government to create a standing army. It's a way of encouraging reliance on the militia, but that doesn't happen, right? The arc of American history here is towards centralization of military power to the point that, from early in the 20th century under the Militia Act, people in the state units of the National Guard are federalized. So that it pretty much doesn't serve the purpose, I think, the core purpose, that the people who demanded it wanted.
I would disagree with that. I mean, it's true that there were many concerns at the time with the federal government taking over, controlling too much. The militias, there were the militia clauses, of course, in Article 1 that were very controversial, and there were many specific proposals made that were all rejected and didn't go anywhere during the constitutional debates, and later on there were proposed amendments that failed, amendments that would have directly addressed the state-federal balance of control over the militia. In fact, it's generally agreed that the language of the Second Amendment has its roots from the Virginia proposal. The actual text came out of a proposal that Virginia made. And what Virginia did is they had a document that had two parts. And the first part was a declaration for a demand for a Bill of Rights. And then it had a list of other amendments. And under other amendments, they had language dealing with this militia issue. And the Second Amendment, of course, was under the rights part. So I think that they were aiming at different things. We can argue about whether it's a military doctrine that the Second Amendment is useful to people who resist in the military or not. But at least at the time it was believed that by having an armed populace, you could definitely check the power of an army. It was believed that that's exactly what occurred during the American Revolution. I'm afraid I don't, though, quite follow the logic of how it is the government can protect itself by arming the population. I guess it protects itself against an invader, perhaps, but if the government's worried about being overthrown, why would it give people guns or allow people to keep guns? That would seem to be counterintuitive, at least to me.
So the word militia was meant to be militia of the people, not a federal militia. And that word is used in the Second Amendment. Militia means a people's militia, not the government's militia.
The militia is composed of people who are serving their community. There's a role for the states, obviously, to play in organizing this. Remember that during the Revolution...
Sure. Article 2, though, does make the president commander-in-chief of the militia when called into service.
Called into service, it's true. But let's also remember, during the Revolution, there were militia. Many of the framers were members of some militia organization or other. There were also the royal militia, the militia that the king had maintained. And these two did battle. They were at odds with each other. And so it's you can talk about the militia being a creature of the federal government, but the idea, insofar as it's meant to protect against the tyrannical force, the idea is that people could act themselves in defense of the country or their liberties.
Great, thank you.
Thanks.
Thank you all for coming. Have a great night, and hope to see you on February 8th for Judge Leslie Disco 7.